show it. So back as the whole Ethan Klein of H3H3 Productions lawsuits came out, and especially the one against Denims, I was already at that time fairly certain that there was no real case here. And now that we have this tentative ruling, I figured I might as well make a video that I wanted to make at that time, but didn't. Because given that I wasn't already making YouTube stuff, there was no direct motivation. And in general, the people who could actually learn something from a video like that aren't likely to pay attention. Partially out of loyalty, partially because there were a gajillion law tubers out there saying Denims is finished. There's no chance. As is, I'm not going to go out there pretending to be a lawyer because I'm not. There's no real way to make that sink. And on the flip side, people who might listen are more likely to be people who just don't like Ethan Klein and are listening to me for that reason, which is also not so educational, So that was kind of where my mind was at the time. But hopefully, now that it has been settled, we can take a look at the situation with the benefit of hindsight and see what copyright law is, how it applies here, and what people may very well have been a bit mistaken about on this topic. So that's my attempt here. Hopefully, it'll be enjoyable. Hopefully, it'll be educational. That's my goal. So to start with, what is copyright? It's a thing people refer to very often without really stopping to think what it even means. And it means what, the words that constitute the term mean. Copy, right. You have a right to make copies. That's it. People think that it's a lot bigger than that, or perhaps smaller than that somehow, but the complexity has nothing to do with that. At its core, it's a very simple concept. Do you have a right to make this copy, or don't you? For instance, if I were to make a perfect, complete copy of Star Wars, for whatever reason, I have violated the copyright of the owners of copyright for Star Wars. George Lucas, I assume, but I honestly don't know anymore. So in this instance, I did not have a right, and I made a copy. Very clear-cut case. Whether I used it for personal reasons or distribution doesn't matter in this case. However, we also have to understand that it can't just be identical copies, right? Because if I were to make a almost perfect copy of the Star Wars and I changed one frame of the whole thing to be slightly desaturated, technically I have now made something that is not a perfect identical copy. But anyone can look at the two and say, yeah, okay, but it's the same thing. You clearly made a copy here and are just trying to get around the thing you did. And that's ultimately kind of where complications arise. Where does that line go? If I replace every other frame, does that count as transformative enough? And that's where that word comes in. Is this enough of a change to say, okay, now we have gone from copy to not a copy. And that's all it really comes down to. So, misconception number one that I feel people might have walked away with from this whole thing if they mainly watched it from the perspective of Ethan Klein and law tubers. You don't need to register anything to have a copyright. Copyright is with you by default, no matter what you do, and I think that's something that I want people to understand better. If I send a text and a third party takes that text and uploads it to Instagram as an Instagram poem or something, that's a copyright violation, and I would be within my rights to call that, a case that they used my copyrighted material without permission. That's real, and that's with you no matter what. And I think in a world where more people are just a single step away from making something that would qualify as copyrighted material, I think that's a good thing to know. The whole registering the content nuke with the Library of Congress has no real bearing on whether or not copyright applies. I think though I guess I couldn't prove this. But the only reason he did that was so that it would be treated as a federal case, because since it's in the Library of Congress, it's now a federal issue, rather than a state's issue. Because if it was in a state, California has protections against lawsuits that are just made to get people to shut up, essentially. I think the term is SLAPP lawsuit, and the laws are anti-SLAPP, where SLAPP stands for Strategic Litigation Against Public Participation, or something like that. And California has laws against this type of thing. I don't want to say primarily, but it's a state where, say, the Church of Scientology has used litigation very maliciously to get people to stop criticizing it. So that's why those protections exist to begin with. And because it became a federal case, those protections can't apply, and therefore the lawsuit will progress whether or not the intent was malicious to begin with. Number 2, in terms of misconceptions. This is the one that I see posted in comments everywhere, and I saw it in the LawTube, I think specifically from Legal Mindset made a big deal out of this. And that is the Denims in the video where she reacts to Ethan Klein's content nuke, says something like, "Thank you for watching my stream, and thank you for watching my stream instead of watching Ethan Klein's awful video." Something like that. And people insist, aha! One of the terms used in copyright legislation is market replacement. And by saying that, you admitted that you created a market replacement. Checkmate, atheists. And this completely misunderstands what the purpose of that line is. Market replacements are legal. We live in a capitalist society. Obviously, if I think I can make a product that is better than something that already exists on the market, I am allowed to try and make a market replacement. That is not something that copyright law is even concerned with. To go to the Star Wars example, if I make my own sci-fi epic on my own time and money and say, watch my sci-fi epic, don't watch Star Wars, mine is better, that's completely legal and has nothing to do with copyright. It's ridiculous to assume it does. Pepsi even marketed Pepsi Cola with the so-called Pepsi Challenge, where they encouraged you, pour a glass of Coca-Cola, pour a glass of Pepsi Cola, mix them up so you don't know which one is which, try them both, and then decide which one you like best. We think you'll like Pepsi better. You should drink Pepsi, not Coke. That's the implication there. And that's completely legal. You're allowed to do that. Market replacements are encouraged, in fact, in, again, a capitalist society. That's how things are supposed to work, allegedly. So the principle of market replacement is not something you're not allowed to do. It's a metric by which we can examine the copyright case itself. So, for instance, if I were to, put the Star Wars example, if I were to take my Star Wars copy with one edited frame and put that into a cinema and display it for audiences, anyone could look at that and see, oh, this is obviously filling the exact same market niche as Star Wars would have done. Not just market niche, this is literally, people are going here to watch Star Wars. They're not watching anything you did. They don't care about you. You have done nothing original here. You just violated a copyright, and that's how you're making your money. That's transparently obvious. There's no real argument you could make to defend yourself there. And by the flip of that coin, if I were to display my own sci-fi epic and show that in a cinema, that's perfectly legal, and anyone could look at that and say, well, that's not Star Wars. Sure, they're watching your epic and not Star Wars, but that's fine. It's not the exact same experience. You did something novel. Now, whether or not I marketed this, showing by saying, watch my movie, not Star Wars, is irrelevant. I could be saying the exact same thing outside both of these cinemas, and one would be a copyright violation because I violated copyright, and the other would not because I didn't violate copyright. The what I said about wanting to replace an original is not relevant to the subject in the slightest. Again, I think this came from like legal mindset. People just ran with it and think that it is something that is a hard legal principle when it very obviously cannot be, or you could not have competition anywhere, ever. There's also much ado made, I think, about a Reddit thread, or Reddit post rather, in the same vein, where people who ran that Reddit, who don't like Ethan Klein, made a list of, do you want to know what's in the content nuke, but don't want to give Ethan Klein views? Check out these videos instead. And similarly, this is perfectly legal and has no bearing on copyright. If any of the videos linked there were violating copyright, then that's a copyright case. If they aren't, then they aren't. The Reddit thread has no bearing on this whatsoever. Again, to me, obviously, Leon of Renegade Cut, Leon, I believe is his name, made a video back when Hogwarts Legacy came out saying, hey, I don't think you should watch Hogwarts Legacy or play Hogwarts Legacy. I think it's destructive and you will be giving money directly to a famous transphobe. Here are some games you should play instead. Again, that's legal. There's obviously nothing illegal about doing this, and it does not suddenly create copyright issues, not for the games being recommended instead, or for Hogwarts Legacy, because, technically, since that one came after, isn't that one the copyright infringing? Like, no. You're allowed to recommend media that is not other media. It's a kind of a ridiculous line to even go down, in my opinion, but here we are. So that was the kind of attempted or like assumed silver bullet by many, and it isn't. What is a silver bullet, and this again is quite important to understand with copyright law, because this is the type of stuff that people will look for when they're judging on these cases, is how can we tell that it's transformative enough? And in this particular case, the silver bullet came in the form of a line that Ethan Klein wrote in his original complaint, which is that Denims used the copyrighted material to achieve the exact opposite of its intended effect. Which, if you are ever suing for copyright, don't write a line like that under any circumstances, because that is just straight up admitting that it's not a copyright infringement. Because the only way that it could be achieving its purpose in direct opposition to the original's intended purpose is if transformation happened. And if transformation happened, it's no longer a copy. There are reasons that people would watch Denims's work instead of the original. The original is the superior product if you want to hear Ethan Klein's intended result. And if you want Denims's intended result, then Denims has made the superior product. They can't be called replacements for one another because what they intend to achieve is fundamentally at odds with each other by Ethan Klein's own admission. This is the only thing that matters in copyright cases. All this other stuff, irrelevant. Now, I believe American copyright law has 4 pillars by which something is judged as transformative enough. I did not read the whole proceedings. It did clear 3 out of 4 of those pillars in Denims's favor. But at least to my mind, again, as a layman, kind of everything before and after that line are almost irrelevant, because such a brazen admission of this is not doing what the original was doing means that there was never a way to win that case. Now, the video I saw back then that I thought was the best in terms of educational value was actually the one made by, Lance of the Serfs, where he has worked in television. He is also not a lawyer and also not giving legal advice, but he has this experience where the advice he gave was essentially, or his perspective on it, his educational content was, Ethan Klein's content nuke was very openly using copyrighted material to begin with. That's just a fact of the matter. And it is not a copyright infringement, as kind of has to be assumed, both for the sake of this case, but also, given that it was registered with the Library of Congress, it has to be treated as its own, valuable material that is not infringing. But it very obviously does use copyright material from others. That's just a part of its structure. And as such, anything that is being called a copyright violation of Ethan's work can't just be granted to Ethan on the basis of it uses parts of his video, because he used parts of others' videos. So, like, you have to apply a consistent standard to both. Using Ethan's work here is reasonable, and it's more reasonable than usual given the original. I'm repeating myself, but I want to get this down. And so the judgment, as will always be the case, mostly comes down to, is this piece of work that Denims put out sufficiently different from the original that Ethan Klein made so as to no longer be able to call it a copy? That's it. What anyone says or recommends or advocates outside of this is not particularly relevant. The only way that it can be relevant, and this is more kind of an academic curiosity thing than anything else, is that if it is found that it is a copyright infringement, then damages will be to be established. And the way that you establish damages is, among other things, whether the copyright infringement was willful, like it was done intentionally. If I am asked to print out a bunch of t-shirts for a friend, for instance, and he gives me an image, and I print the t-shirts, and it turns out that that was a copyright infringement. He did not have rights to that picture that I printed out a bunch of t-shirts of. If I could prove that in a court, I would be treated as someone who committed, not willful copyright infringement, and that means that I won't have to pay as much. And that's it. If it had been found that Denims had violated copyright, her damages would be much higher as a result of her saying something like that, because it's obvious that she knew that the original existed and she was making her content in light of that. And that's kind of all that really amounts to, in case you were curious. So, I want to tie it back again to what copyright is. Copyright is about making copies. Complications only really occur as a result of deciding what exactly is a copy. And that's it. That's the TLDR, I guess. And at this point, I really would appreciate feedback on whether this type of thing is educational, whether it's something you enjoy and are enlightened by. That's the only goal at this point. So I would love to hear that type of feedback if that's what it achieves for you. And peace out.